Friends, ladies and gentlemen, good afternoon. I'm so happy and honored to welcome all of you to the centennial celebration of the UP College of Law. To many of you, I'm sure this is a homecoming. The aftermath of the people power in 1986 was not easy. It was a period of political tension and economic distress. It was, however, the most appropriate time to implement political and socio-economic reforms. To do exactly this, radical changes have to be done to the 1973 Constitution. The Aquino government did more than that. It abandoned the 1973 Constitution altogether, and the 1987 Constitution was born. The 1987 Constitution is a bastion of civilian supremacy. It also championed devolution of power and public accountability. Understandably, the President's extraordinary powers were narrowed and restricted. The powers of the judiciary were expanded, and a Human Rights Commission was created. Indeed, the 1987 Constitution was a reaction to the political and economic conditions during the martial law years. This afternoon, we shall look back to history through the eyes of no less than one of the chief legal advisors of then-President Marcos. I am referring to then Solicitor General Estelito Mendoza. We are privileged to have him this afternoon. Here in the UP College of Law, we call him as the lawyer's lawyer. The great Estelito Mendoza graduated cum laude from our college. He belongs to the legendary class of 1952. He obtained his Master of Laws from Harvard University and joined the faculty of our college. As a law professor, he is one of the most revered who taught almost every branch of the law. He was a legislator when he was elected member of the Interim Batasang Pambansa and was a local executive when he was appointed governor of the province of Pampanga. Our lecturer has been to all branches of the government except the judiciary. But as the Solicitor General, he was regarded as the 16th Justice of the Supreme Court. It is said that the people power and its fruit, the 1987 Constitution, are the great testimonial to Philippine postmodern democracy. This afternoon, we shall go one step further and see whether or not the 1987 Constitution is in reality a Marcos legacy. Thank you, and mabuhay po tayong lahat.
And now to give us the lecture, the 1987 Constitution, a Marcos Legacy, I'd like to call on Attorney Estelito P. Mendoza.
President Pascual, I am privileged to have the UP President here, no less. Dean Concepcion, members of the faculty. Shall I finally say fellow students? Because I remain a student up to now. let me start by saying I have a problem. I have a hearing problem, but I cannot control what I would hear and not hear, except as to my wife. When I know she is going to give me a sermon, I just take off my hearing facilities. The 1987 Constitution, a Marcos legacy. Provocative, intriguing, stimulating, even seductive. But I can assure nothing sexy about what I'm going to say have been said of the subject of the title of my lecture. Allow me, therefore, to immediately relieve you of your anxieties. Never again, President Marcos, that appears to have been the primary, if not the dominant and consuming mission of the Constitutional Commission in drafting the 1987 Constitution. The image of President Marcos seems to have been at all times in the mind of the members of the Commission. Fundamental provisions of the 1973 Constitution, including those derived from the 1935 Constitution, apparently perceived to have been instrumental in the assumption and exercise of the powers of government by President Marcos, have been exorcised from the Constitution. In the process, the historic distribution of power of government among the executive, legislative, and judicial departments have been altered. The relative weight of checks and the consequence balance have been changed. Principally, presidential powers have been emasculated, and although in a lesser category, legislative power as well. The ultimate checking function has been vested in the judiciary. The scope of judicial power has been broadened, overreaching its traditional role as arbiter. The President's power as Commander-in-Chief emasculated. President Marcos issued Proclamation number 1081, proclaiming a state of martial law in the Philippines on September 21, 1972, by virtue of the powers vested in the President in Section 10(2), Article 7, otherwise known as the Commander-in-Chief Clause of the 1935 Constitution that was still in force. It provided as follows. To expedite, I will assume you know these provisions. I will not read them anymore. Section 11, Article 7 of the 1973 Constitution is a verbatim copy of the same provisions. The powers of the President as Commander-in-Chief were principally the target of emasculation by the 1987 Constitution. This was accomplished in its Section 18, Article 7 as follows. A. The imminent danger phrase was eliminated in the 1987 Constitution. As a consequence, the President may only suspend the privilege of the writ of habeas corpus or place the Philippines or any part thereof under martial law in cases of invasion or rebellion, unlike both under the 1935 and 1973 Constitutions, where he may suspend the privilege of the writ of habeas corpus or place the Philippines or any part under martial law in case of imminent danger of such contingencies. And B, second, under the 1987 Constitution, the suspension of the privilege of the writ of habeas corpus or the proclamation of martial law can only be for a period not exceeding 60 days, while under the 1935 and 1973 Constitution, no duration is provided. Unlike the 1987 Constitution, the President is required within 48 hours from the proclamation of martial law or suspension of the privilege of the writ of habeas corpus to submit a report in person or in writing to the Congress. The pertinent provision of the 1987 Constitution reads as follows. I will not read it anymore. D. Not only Congress, but the Supreme Court may review the suspension of the privilege of the writ of habeas corpus or the proclamation of martial law, as the 1987 Constitution provides, and I read this provision, Section 18, the Supreme Court may review in an appropriate proceeding filed by any citizen the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus or the extension thereof, and must promulgate its decision thereon within 30 days from its filing. You must note, it says, the sufficiency of the factual basis of the proclamation of martial law. So if the proclamation says there is a rebellion, you need to present evidence that there is a rebellion or whatever it is. Next, the consequences of the proclamation of martial law are explicitly limited in the 1987 Constitutions. I will just abbreviate this. A state of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or the legislative assemblies, not to authorize the conferment of jurisdiction in military courts, etc. That is because this was what was done when President Marcos proclaimed martial law. The suspension of the privilege of the writ shall apply only to persons judicially charged for rebellion or offenses inherent in or directly connected with invasion. Frankly, I do not understand it. If there is a charge already, you do not need the suspension anymore. During the suspension of the privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days, otherwise he shall be released. Well, that is actually contrary to the purpose of a suspension. Anyway, the above provisions of the 1987 Constitution are detached from reality. They were apparently conceived in a vacuum. When there is an invasion or rebellion, actual and present, we can hardly imagine a Supreme Court holding a trial to determine questions of fact, or a Congress debating and deliberating on the propriety of the proclamation. Should there be an invasion or a rebellion with the incident disorder and chaos, the President as Commander-in-Chief responsible for the preservation of the state, when he sees the need to proclaim martial law or suspend the privilege of the writ of habeas corpus, he will, in my view, proclaim martial law and suspend the privilege of the writ of habeas corpus and simply ignore the explicit provisions of the explicit required restraints provided in the 1987 Constitution. On hindsight, I have been often asked myself whether President Marcos would have declared martial law had the Commander-in-Chief clause been as it now appears in the 1987 Constitution. I was not privy to the issuance of Proclamation number 1081, although some believe that I was or that I had even drafted the proclamation. The belief may have been fueled by the fact that just a few days before the Proclamation 1081, I was at a well-publicized meeting of generals of the military where I was the only civilian. I was as surprised at its issuance as the people generally were. Let me narrate a meeting at Malacanang soon after the issuance of Proclamation number 1081 was announced. This would give a sense of how President Marcos regarded law and of the question I had earlier raised. Soon after the issuance of Proclamation number 1081, several persons, notably Senator Benigno Aquino Jr., were arrested and detained. Petitions for habeas corpus by many of those arrested were filed with the Supreme Court. The Supreme Court promptly directed the respondents, principally then Secretary of Defense Juan Ponce Enrile, to file returns. President Marcos then called a meeting at Malacanang, which included Secretary of Justice Vicente Abad Santos, who was Dean of the college before, and myself, who was Solicitor General, and many others. The issue he raised at the meeting was how government would respond to the petitions for habeas corpus. As an initial and basic issue, he requested us to advise on whether the government would recognize the jurisdiction of the Supreme Court. One view was that the order of the Supreme Court be ignored and to declare the government to have become a revolutionary government. He then asked me directly whether I thought the validity of the proclamation of martial law and the suspension of the privilege of habeas corpus could be justified as constitutional. Without the benefit of a study, I hazard that I possibly could defend it by invoking the political question doctrine, which would constrain the Supreme Court from inquiring into the factual basis of Proclamation number 1081. I had in mind the decisions of the Supreme Court in Barcelona versus Baker and Montenegro versus Castañeda, which barred judicial inquiry into proclamations suspending the privileges of the writ of habeas corpus. Likewise, because of insurgency or subversion intended to overthrow the government, and the more recent case of Lansang versus Garcia, in which case the Supreme Court, while not adhering entirely to the earlier cases of Barcelona versus Baker and Montenegro versus Castañeda, limited judicial inquiry to determining whether in issuing the proclamation the President acted arbitrarily. After discussion, President Marcos decided that the government would recognize the jurisdiction of the Supreme Court, and I would defend the validity of Proclamation number 1081. As an observation in regard the proposal that the government simply declare that it had become a revolutionary government, which would have made my job irrelevant, not just easier. He suggested that if the Constitution would effectively be no longer in force, and this is significant, the military particularly may feel that there were no limitations to the power of government. There would not be any constraints to the authority of the military as administrators of martial law. It is better, he indicated, that the Constitution continue in place and in force, and in which the government would be operating would be under the Constitution. I would like to call your attention, perhaps because President Marcos was a lawyer. I do not know whether because he is an alumnus of the UP College of Law. If the question is whether there was rule of law during his tenure, there is no question at all that there was rule of law if the rule of law means acting in accordance with law. He made sure there was a law which was to be the basis of every action of his, even if he had to make the law himself. But the point is, and what is significant about what President Marcos' assumption of power is that he assumed responsibility for every act he did. He did not hide behind any scheme in utilizing other agencies of government to perform what he did as president, so that every arrest, search, and seizure order issued at the time, and there were thousands of them perhaps, were personally signed by President Marcos. I do not think there is any head of state or head of government who has ever done that. Every presidential commitment order was signed by President Marcos, not by the executive secretary in behalf of the president. The validity of Proclamation 1081 was upheld in Aquino versus Enrile, which was a consolidation of several petitions for habeas corpus filed by persons arrested and detained on September 22 to September 30, 1972. Hearings were held on September 26, 29, and October 6, 1972, at which hearings the petitioners were produced in court. The decision in the case was promulgated on September 17, 1974, nearly 2 years after. I would like to mention to you, which you may consider in light of present practice, that every petition for habeas corpus was heard by the Supreme Court. And on occasions when the matter before the court was of such complicated nature, the Supreme Court held hearings on the case for several days, and that was my job. That was why, by actual count, I was told that I had appeared in the Supreme Court during those times nearly 1,000 times. I was asking once Senator Joker, who was my classmate, I said, why do you keep on appearing? Talo naman kayo palagi. Hindi, sabi niya, mabuti na rin imapahayag sa buong mundo kung anong nangyayari dito. So, and I think we made a plausible stand. The arguments we submitted were plausible enough to merit the consideration even of international observers. While there was near concurrence of all the members of the Supreme Court on the dismissal of the petition, incidentally, they all agreed that rebellion existed at the time. There is not a single opinion which expresses the decision of the court. Instead, there are 6 separate opinions, and as now printed in this graph, consisting of 468 pages. I think no matter what is being said or has been said of the Supreme Court at the time, it can hold its head high simply if you will read the opinions as printed in this graph. They would not suffer by comparison to any decision rendered by the Supreme Court now or before. What must not be overlooked is that after the issuance of Proclamation number 1081, the arrest and detention of many distinguished personalities in the opposition as well as media, did not provoke or incite widespread protests against the proclamation of martial law. I think that is significant. People accepted it. Conditions became better. Even curfew was welcomed by the people. The economic conditions of the country improved. That is what Prime Minister Birata said recently in an interview published in the Star. I would venture the observation that the people in general were happy about the conditions in the country, which were attributed by many to the proclamation of martial law. For those who would like to wrestle with the question of what influences a court to decide the momentous cases of political significance, the question should be as to what extent did the conditions which prevailed immediately after and for some years after the proclamation of martial law influence the decision, and several decisions later. Of what most relevant is that apparently President Marcos, in proclaiming martial law to address an actual rebellion seeking to overthrow the government, took a very broad view as to what was necessary to quell the rebellion and assure the stability of the nation. What he wanted to do was to establish what he would call a new society, utilizing the powers under martial law, not just to preserve the status quo, but to bring about changes necessary to provide stability and prosperity to the country. There is one characteristic, and perhaps obsession of President Marcos, and it is that he wants to ensure that every act of his is in accordance with law. Utilizing his power to legislate derived from the proclamation of martial law, and that is controversial, and later under the 1973 Constitution, particularly its Amendment number 6, he legislated by the issuance of presidential decrees and letters of instructions. Indeed, the administration of President Marcos is noteworthy for the number of laws denominated as presidential decrees or letters of instruction issued. All in all, during that period, 2,053 presidential decrees and 1,504 letters of instruction were issued. This would include 14 codes. Significantly, the 1987 Constitution provided that these laws shall remain operative. Its Section 3, Article 18 so provided. By virtue of this provision, many, if not most, of the presidential decrees remain effective. All of the presidential decrees, particularly and especially the codes, were prepared by those knowledgeable in that area. For example, the Labor Code was prepared by the Ministry of Labor, then headed by Minister Blas F. Ople. So you have a situation where decrees or laws were enacted, prepared by technically prepared people, and without the necessary and usual influences of lobby of interested or partisan groups. That is how the laws were then enacted. They had that virtue, and apart from that, they were expeditiously promulgated. Perhaps I may mention to you that now we are talking about the problem in the South China Sea, popularly known as Spratly. If President Marcos did not have that power, and he had the guts and the boldness to do what he felt was necessary, the Philippines would not be talking of any claim there. This claim came about only when Admiral or Cloma, we call him Admiral at the time, discovered, he says discovered, but the point is they were uninhabited at the time, to cover these islands, and he went to President Marcos because the Chinese were already threatening to overcome him. And he said, Mr. President, I am willing to cede all of this to the Republic of the Philippines, provided I retain private ownership. Where Marcos said, no, you cede them, but you do not retain private ownership. So right then he told me, prepare the decree by which we declare these islands as belonging to the Philippines, and we constitute them as a municipality, part of the province of Palawan. That is how it started. Well, just among us, no study, no research, just declare, and without that, there would be no claim at all. So it was my task after that to find historical basis for the claim as well as legal basis. Incidentally, in order to determine whether there were historical foundations, I availed of professors of history of the University of the Philippines. This, shall we say, committee or task force, as they call them now, was headed by Professor Serapin Quezon, who was a member of the history department of the UP, and they produced an excellent work. But the work must continue, and it has continued to, at the present time, so that with the Law Center providing some legal foundations for it, but it is not complete. I am afraid the present administration has stopped working on it.